started right now. Again, we're going to have Bob Silber. Again, folks, I talked about Bob a little earlier today, and one of the things that Bob has and what he talks about is something that no one talks about on the Internet, because there's no one qualified to talk about this on the Internet. And that's a big point, because this part of business, this part of Internet marketing is strictly business itself. You have to be a smart business person to market online. You're not going to have a successful business if you go about it in all the wrong ways. You need to keep your business. You need to know what you're doing. You need to protect yourself. And Bob's going to show you how to do that in the next 90 minutes. So everybody put your hands together for Bob Silber. Thank you.
Thank you. Before I start, I need to always give a disclaimer. And the disclaimer, and you'll learn about disclaimers and the importance of them. And the law allows you to use warranties and disclaimers to your advantage. And once you understand them and what you need to do, you're going to be in a much better legal position than you are now, and save yourself a lot of headaches and aggravation. Now, my talk is not intended as legal advice or as legal opinions on any specific matter, and it certainly is not a substitute for competent legal advice. And the reason for that is every situation is different, and you need to really sit down with somebody and listen to their facts of their situation. Also, the law changes from day to day. I was giving a talk back in October in Minneapolis, and one of the things I was talking about was the Madrid Protocol system, which is an international trademark. And we hadn't, as in the United States, Congress had not passed that legislation for 15 or 20 years, which was really a good way to get international trademarks and saved the member countries a lot of money. Well, while I was on stage giving that talk, they passed the legislation. So that's why you need these disclaimers and caveats. The law changes from day to day, and this will be for educational purposes only. And of course, all of the laws are always subject to exceptions. Nothing is black and white in the law, and they vary from state to state. So I'm not going to have any responsibility for any actions you take based on this information. But the value of this information to you is that you will be aware of what you need to know, and you'll be in a much better position then to speak with an attorney when the situation arises. You'll know exactly what to do. So this information is presented as is. It's not foolproof, as I said, but it certainly will put you in a much better legal position, and you'll be able to be at the top of your game when you're doing your website and thinking about what you need to have on it. Now, we're going to have a lot of content to cover today, so I want everybody to feel free to answer questions as we go along. There really aren't any stupid questions. And the reason for that is I'd rather have the question asked, because everybody learns from questions also, rather than just sit there and have something in your mind that you wanted to ask but were afraid to interrupt. Don't be afraid to interrupt me. If you have a question, just raise your hand or shout it out, or however you want to do it, and I'm sure it'll benefit you as well as everybody. Now, some of the topics, depending on the time that we have that I'd like to cover, you all agreed this morning that you wanted to hear about how to keep the government off your back, and that was the majority of you wanted to hear that, if not everybody. And the way we're going to do that is we're going to be discussing choice of forum statements, choice of law statements, warranty statements, and disclaimer statements. Then later, if we have time, we may discuss price-fixing product rules and reprint right licensing. The rest of it, I know we're not going to get to, the copyrights and trademarks, because there just isn't enough time to do that. Now, how to do business on the internet while keeping the government off your back. There are 4 things that you must have on your website. Must have. to save you time, money, aggravation, and legal problems. First thing is a choice of forum statement, and I'll explain these in a little more detail in a moment. Choice of law statements, warranty statements, disclaimer statements. Now, all this information that I'm giving you today certainly isn't to take advantage of anyone. I mean, nobody wants to do that, and if you were to do that, you certainly wouldn't be in business very long on the internet. Word gets around fairly quickly on the internet. But what it does do, it protects you legally from what I like to refer to as the lunatic fringe element that we have in the world. So the internet is global, our business is worldwide, and you need to comply with the laws of the country that you do business in. So if you're doing business in the U.S., of course, then you need to comply with our laws foremost, and any other country that you do business in. And the jurisdictions are worldwide because it is the internet, the World Wide Web, and you'll be getting orders from, all over the world, Australia, England, wherever it may be. It's a big market out there. So disputes are international, and any disputes that you do have with somebody that isn't from the U.S. Are subject to international laws, but there is a way around that, hopefully, and as I said, we're going to discuss the disclaimers and warranties and how you can use them to protect yourself. Now, litigation is expensive, it's aggravating, it's a nightmare. I mean, if you have a law, if somebody sues you from California and you live in Florida, where I do, I mean, that's no fun. I don't want to be going to California to defend myself in a lawsuit. It's bad enough if I have to defend myself in Florida. And certainly if somebody in Australia sues me, I don't want to be going to Australia, to defend a lawsuit. Maybe to go marlin fishing or something, okay. But these are all things that you need to know and that you're exposed to because you're doing business international. Now, which nation's courts will hear a dispute? These are important questions. And what laws should be applied to the case? And even what language is the contract interpreted in? This is where the warranties and disclaimers come into play. And as I explain this, it'll become more clear. Now, in its simplest form, you don't think in these terms, but if you go on the internet and you buy a product, let's say you buy an e-book, you think of it as a sale. Okay, I'm making a purchase. But the law views that as a contract between you, the seller, and the buyer. So all of the law for that transaction would have its genesis in contract law, because it really is a contract. Now, the great thing about contract law is that people that enter into a contract are free to contract to the terms that they want. Free to contract to the terms that they want. This is important because this is how we're all going to benefit this afternoon, by this information. And you can contract to any terms that you want as long as the other side agrees to it, including the jurisdiction of the courts. For instance, if I have my website and I'm doing business in Fort Lauderdale, Florida, I may have on that website, this is a contract between you, the buyer, and our business, the seller. We are located in Fort Lauderdale, Florida, and you are choosing to do business with us. Those words are very important because the courts look at whether or not the bargain or the contract entered into was done voluntarily. So you are choosing to do business with us. So if you come to my website, you're choosing to do business with me. And on the site, I'm going to have disclaimers and warranties. And if you don't agree with that, After you look at them, then you're free not to do business with me. So that's how the law looks at it, and that's the legal method that we use to protect ourselves. You are choosing to do business with us. Now, another thing is you agree that the offering is made from Fort Lauderdale, Florida, and I'm using Fort Lauderdale, Florida only as an example. Obviously, wherever you're from, that wording would change. And shall be governed by the laws of the state of Florida and the USA. All right? Because I don't want the laws of Australia applying or the laws of Germany applying when somebody comes in to do business with me. The other thing is you are electing to participate in this offer. Very important words. You are electing to participate in this offer. Why? Because, again, the court looks at all this as to whether it was voluntary. Now, the terms for choice of court. Again, you are entering into a contract, and the terms constituting this offer are set forth in writing on the website, and you agree to submit to the jurisdiction of the state and federal courts located in Fort Lauderdale, Florida, to resolve any disputes. So now, what does that do? The law allows me to do this. So if you're from California or Iowa and you sue me, where's the case going to be heard? Exactly. So I'm going to be comfortable in my little beach wear with my little cabana, beach cabana, and you're going to be flying in from wherever you are from to conduct any litigation that you want to. These are all legitimate things that the law allows. Now, whether or not you choose to print this offering containing the terms and conditions described herein, you agree that this offer constitutes a writing. Now, the reason for that is, again, a written contract. The law treats a written contract differently than it does an oral contract. So that's why that statement should be on your website. Now, this agreement is being written in English, which is to be the official language of the contract's text and interpretation. All right, so what does that do? You know, I went over to England, and some of the words we use here over there for some reason have a different meaning. And when I visited Australia, the same thing. So I want whatever is on my website, when I write sales copy, I want it to be interpreted under the laws of the U.S., that we have in the U.S. I don't want that sales copy or sales presentation to be interpreted in some other language, because language does differ. So these are important things that you need to know when you're doing business internationally. Again, if you do not agree to the above terms, you have the option not to participate in this offer. And that's always important, because the courts look at that and will say, well, listen, you had a choice. You did business with them. You agreed to do business with them. That's your choice. You can't be heard to complain now. Oh, yes. Yes, on my site there's a website package that I do a custom warranty disclaimer, terms of service, privacy statements, whatever it is that you need for your site. All right. Any other questions? Yes. I'm sorry. Great question. Yeah, the question is, do you have to have a button, I accept? In other words, you go to if you've ever installed software, which I'm sure you all have, you have to accept it before it lets you go and continue on. So that's a great question. And the answer is, you certainly would be in the best legal position if you had that button. Matter of fact, I just had some software produced, made that it's done. I just have to find the time to sit down and throw up a website for it called the verifier, where you just put in the words and you push a button and it spits it out, the code, and you put that on your website, and it requires a person to verify that they did read the terms and conditions. As we go a little further into the presentation, you'll see that the disclaimer and warranties either ideally, as you stated, has a button that you can click on, or if it doesn't, at least a link that's larger or noticeable, and that's the key. And I'm sorry, what? A link that's noticeable, larger font. Maybe if your sales presentation is in a 12-character font, the 12-point size, then maybe you want to put your link in 14-point. Yeah, this is the link for the terms and conditions and your warranty and disclaimers. Yeah. Just the same as you prove anything in any court by testimony. It's no different than any other proof that you need to prove your case in court. Well, you can always print out a hard copy of your web pages and it dates it on the printer. At least it does on mine, and that's the least really of the problems. I think that takes care of itself. Yeah. Good question. Ideally, the question is, where do you want to put all this stuff, right? All right, where you want to put all this stuff. Ideally, the law, the Federal Trade Commission, wants you to put the disclaimers into the sales copy right where you need them. But, I do internet marketing, and I don't like killing my sales, so, I take a long time to write my copy, and I don't want every other sentence or paragraph having a large disclaimer in larger font there. But that's the ideal situation. But listen, that's not practical for us as internet marketers, is it? So the next best thing is to have, as you mentioned, the little button that you can click. And again, I'm coming out with that software. I wish they had it now that you mention it. It's sitting there for like 2 months ready to go, and I haven't got to it, like so many things. Yeah, that's what you need. What you need to show the court in the best way that you can is that these disclaimers and warranties were read. And so we're thinking if you go into court and they have to click on a button before they can proceed to the order page, then certainly the court is going to say, well, you read that, or you certainly said that you read it. So that's the best possible scenario that you have. Yeah. Well, I'm sure there are, but we're sort of relegated to doing business where we live. I'm in Florida, and unless I want to search out a web server in a particular state, and then you'd have to go and research the 50 laws. But your big problem is the Federal Trade Commission, the FTC, because they're the ones that are surfing the internet, looking at your website. And certainly if you have a customer that asks for a refund and they're unhappy and they report you to the FTC, and And the Federal Trade Commission, they're the internet police, go over to your site, and you may have problems. A good example is I was talking at Carl Galetti's Internet Marketing Super Conference last year, and we were talking about warranties and disclaimers and the Federal Trade Commission. And as a matter of fact, if you go to my site, you'll see this. When I got home from the conference, I had a lady, her name was Rufina James, very nice lady. The reason I'm using her name is she gave me permission to, and I have it on my site. She got back from the conference after we're talking about this stuff, and what do you think she has in the mail waiting for her? Yeah, a letter from the Federal Trade Commission threatening $100,000 in fines, saying that they copied her website. They sent the copies of the website to her state attorney general, and it's just a nightmare. So we need to head off these nightmares before we get to them, and certainly this is the way to do it. Great question. Great question. The answer is they don't tell you. How about that? How about that for a government agency? You're in violation. You're facing fines of $100,000 a day. We've copied your website. We've sent it to the state attorney general. So, what's your next move? I mean, they don't spell out the violations. Sure, but you can't please all the people all the time, Some people you give a refund and give them more money and polish their car, wash their car, and they still want to hurt you. That's the lunatic fringe that I talk about. Yes. Yeah. Yes. Sure.
I have a request here. The visual people cannot get the questions. Can you repeat every question?
Sure. We'll try that.
And I've asked them that if you forget that they will just holler out, repeat the question.
That's the best way. That certainly is the best way. Yes, sir. Okay. The question is, in that scenario, how do you determine what you did wrong? The answer is you need to go to somebody that specializes in internet law, an attorney, and find out what you did wrong, and then comply with the attorney's advice, then write them back that you believe you are now in compliance. Somebody that's trained in internet law, I can go to a site and look at a site and give you a pretty good indication on whether or not you can have problems. And again, we talk about an unhappy customer. The FTC has people surfing the internet all the time, so it doesn't need to be an unhappy customer. Are there attorneys listed? Is there a site for attorneys that you can get names to call because you don't know who to call? And the answer to that is yes. In the search engines, you can do searches for attorneys. You can call your local bar association, but you need to recognize that if it's an intellectual property attorney or an internet attorney that knows what they're doing, you're going to be paying a little more than the standard rate for an attorney. So yeah, you can just hit the search engines, or you can call me. That's what I'm here for. What was the question? Okay, how real does your testimonial have to be, and how much evidence do you have to keep on file? Now, we're all marketers. I like internet marketing. And when I get a great testimonial, I go, all right, let me just throw this up there. You are responsible if somebody sends you a testimonial for verifying that what they are sending you is the truth. You can't just put it up because somebody gave you something in writing. The Federal Trade Commission says it's your responsibility. You need to investigate and you need to substantiate that in fact what they're telling you is true before you use that as a testimonial. Yeah. The question is, what is your exposure if you have affiliates selling your product and they do something wrong? Is that, or well, yeah, then you do. You have a liability for that. You have a liability if you're selling a product that causes damage. So you need to, deal with reputable people and reputable products, or else you can have serious problems. Well, when you say they're doing, the question is, what about the other way around? If you have affiliates that are doing something unethical, the best way to handle unethical affiliates is just to shut them down and not have them as part of the program when you find out. But if we're talking spam or something like that, yeah, the problem's going to come back to you. But we're talking more in the arena of violating criminal laws and civil laws where you have serious civil liability and damages from the government. Yes. Is it my experience that making false claims on your website about health or nutrition, is that one of the things or results the Federal Trade Commission goes after? That's at the top of their list with some other things, yes. So you need to be especially careful, if you have a productive website selling, what is that new Coral something, I don't know. Coral calcium, that's it. And you go to some of these sites and they're making claims that they shouldn't be making, and you certainly run into problems a lot faster when you put yourself in that situation. Any other questions before we go on? Go on, okay. All right, the choice of laws. The U.S. has entered into several treaties to facilitate international disputes. But as I said, if you're using the disclaimers and warranties that you should be, hopefully you'll be avoiding these. But the 1970 Hague Convention, just for your information, they entered into that convention. When the law talks about a convention, they're not talking about like a convention that we have here. What that means is simply like a treaty. An agreement, a treaty between countries, between nations. So that's what they mean by the word convention. And one of the conventions that they entered into is for conducting discovery internationally. Like every lawsuit that you're involved in, you need to take discovery, which is a gathering of evidence. So how do you do that if somebody's in Australia? Well, the convention that we've entered into allows us to do that. And also, discovery includes the pretrial gathering of evidence, which you need to do in every suit, and there's a means to do that, too. Another one is the 1965 Convention on the Service Abroad of Judicial and Extrajudicial Documents. When you're suing somebody, in order to start the process, you need to serve them with papers. All right, so this is what they're talking about. If somebody's in Australia, how do you sue them? You would need to follow the rules in civil and commercial matters, and that provides a mechanism for serving court pleadings so that you're able to proceed with a lawsuit. Now, courts, of course, may consider other factors in determining venue and venue simply meaning where the court case is going to be held. But certainly including a choice of forum and a choice of law clause that we discussed puts you in a better legal position, a much better legal position than if you didn't have it at all. And hopefully will keep you in your home state and your home city if you have any problems. All right, let's look at warranties. What are warranties? Warranties are simply a consumer's assurance that the product purchased meets certain standards. Now, we need to know how warranties are created. They may be expressly stated. In other words, you warrant that this is how this software is going to operate, or this is, if you're selling a product, a kitchen knife, this is how this kitchen knife is going to operate. That's an express warranty. Now, warranties can also be implied by law, and that means by looking at the surrounding circumstances of your sales presentation when you're writing sales copy. Depending on what you write, they may imply a warranty by law. Now, the dangerous thing is that you can create warranties by mistake and unintentionally, and we'll get to that in a minute. Now, you're not required as sellers to make warranties, so the question is, why do you make them? People make them in order to put the consumer's mind at ease and to make more sales. Now, express warranties are created by writing, and that's simply your website sales presentation. They're made by oral representations, anything that you may say to somebody, whether it's over the phone. You know, I get calls from England, I get calls from Australia. Anything that I would tell somebody in reference to any of my products may rise to the level of an oral representation and create a warranty. And they can be inferred from the conduct of the seller also. Now, as I mentioned, a warranty can be created unwittingly. It can be created by mistake, and these are the dangerous areas. No special wording is needed to create a warranty. Now, statements can unintentionally create a warranty, depending what you say on your website. Representations can unintentionally create a warranty. Now, the courts construe statements made by the seller to be part of the basis of the bargain, in other words, part of the contract. So any statements that you may make may enter into being part of the contract that you enter into. Now, a retailer has liability for any express warranty made by the manufacturer of a product, and that's what we were talking about earlier. When somebody asked the question, you sell a product on your site, are you liable for that product if you didn't manufacture it? Yes, you are. So you need to make sure that what you're doing on the internet is just like you would do if you had a retail store. Now, the internet is a great medium. It allows us all to make a lot of money, but you just can't throw the rules of common sense out the window. And a good way to approach it is, would you do this if you had a brick and mortar retail store? Now, the retailer has liability for any express warranty made by the manufacturer of a product. Now, the law has what they call sales puffing, and puffing is considered to be an opinion. Now, of course, the difficulty comes in determining, and there's thousands, hundreds of thousands of court cases, is exactly what is puffing. Now, let me give you an example. For example, if you have a website selling a software program for $19.95, and you make a statement that the software is worth $97 in your sales copy, when you're writing your copy, that doesn't create a warranty because it is an opinion of the value. All right? These are fine distinctions, and they're certainly arguable when you get to court. Now, on the other hand, statements construed as facts can create a warranty. such as software will make your computer run 10 times faster, or the software won't need updating for 5 years. These are statements of fact that the buyer should be able to rely on from the seller. So they're going to rise to the level of a warranty. And in a moment, we're going to get into how you disclaim these warranties so that you don't have these problems. But you need to know about the problems so that you know why you need the disclaimers. The implied warranty of merchantability applied to your products is by operation of law. You do not expressly have to state those terms. You sell a product to do something, then there's an applied warranty of merchantability and created by law unless you disclaim it, which we're going to get into shortly, as I said. Now, an example of that, unless properly disclaimed, the goods must be usable for the ordinary purpose for which they are used. Let's say, for an example, you're selling those Ginsu knives or some other knife on your website. That's your product. Website sells a sharp kitchen knife and it breaks with normal use. That's a breach of an implied warranty, and you're going to be liable for that. An example, breaks while they're using a knife as a screwdriver. You're not going to be liable for that because that's not the intended purpose or the ordinary use of the life. Now, the implied warranty of fitness for a particular purpose arises by operation of law. Now, the seller knows a particular purpose the buyer is purchasing the product for, and the seller states that the product will meet that need, and the buyer relies on the seller's expertise. Now, let's say, for example, that, just as an example, you're selling surge protectors on your website, and you have all this great sales copy, and the surge protector is $19.95. And you get an email from a lady in a different state, and she says, look, I have a lot of power interruptions, and I'm afraid this is going to hurt my computer. Will that protect me? And you write in the email back to her, yes, we have a great product. It's only $19.95. You want to make that sale. If it's a $100 sale, you want to make it a little more. Well, that's going to rise to the level of a warranty if there's a problem. Now, you might say, well, what's the problem? If there's a problem, I'm going to give her a $19.95 back. That's not how it works, ladies and gentlemen. It should only be so easy. Let's say she uses her computer for business and plugged in that $19.95 surge protector. You're going to be liable for her business records if she loses them, her business losses if she has business losses. Now you can begin to see why this all becomes so important. You're not limited to the little $9.95 ebook in terms of damages that you face, or you're not limited to the small retail price of a product or just giving refunds. You can get into all kinds of damages depending on the product that you sell. And, we talked a while ago about making representations about how much money you're going to make or this or that. People certainly can get into a lot of trouble making those representations unless they're properly disclaimed. Now, how do we minimize our liability for our online product sales? This is what we need to know. What needs to be done to disclaim warranties? You need disclaimers and disclosures for your website ads. You need disclaimers and disclosures for your website sales presentation. And you need disclaimers and disclosures for your product. Now, Article 2 of the Uniform Commercial Code is accepted in whole or part in all of the 50 states, and that establishes certain warranties that apply to the sale of goods. Now, subject to state laws, and there's a federal law called the Magnuson-Moss Warranty Act, Express and implied warranties can be disclaimed or limited. Congress enacted the Magnuson-Moss Act in 1975, and that act is administered by our friends at the Federal Trade Commission. And the act regulates written warranties relating to consumer products. Now, that act makes it easier for purchasers to sue for breach of warranty, making a breach of warranty a violation of federal law. Now, again, you buy a $9.95 ebook, happy to give you your $9.95 back. Again, that's not the liability you're facing. That's not how it works. An attorney can sue you. You could be responsible for court costs and attorney's fees, which can run into a lot of money. So the liability is there unless you make the proper disclaimers. You lose a lawsuit for breach of either a written or implied warranty. You have to pay the customer's costs for bringing the suit, including lawyer's fees. Now, let me ask you. You go and you buy a $20 product, the surge protector, and you go plug it in and it ruins your computer, ruins your business records, you lose all your business records, and you need to go into an attorney's office, to find out what you can do. Well, you walk in and say, look, I bought this $20 surge protector. Without the act, an attorney's going to say, well, it's just not going to pay you to pursue the suit. But when they know that they're getting attorney's fees and court costs paid right off the bat, then they're all too happy to take the case. So this was done purposely by our government in order to give consumers remedies so that they'd be able to seek redress in the courts for these problems. Now, as a seller, you need to be aware of these things and protect yourself against it as best you can. Now, Magnuson-Moss lawsuit can be brought in either state or federal court, and due to the stringent federal jurisdictional requirements, the class actions are usually brought in federal court, or one suit is brought in the state court. That's another thing. If you have continuing problems and you get an attorney that sues you, they know they're getting their attorney's fees and court costs paid. The first thing they do in discovery, remember we talked about discovery earlier, where you take depositions or interrogatories, ask questions of the other side. They're going to ask if you had any other unhappy customers. They're going to subpoena all your records. And if there's enough people that you've had problems with, then they're going to file a class action suit, which then can run into astronomical sums. Now, if you sell a product for more than $10 and you choose to make an express warranty, the Act requires you to label your warranty either a full warranty or a limited warranty. A full warranty guarantees free repair or replacement of your product, and it must indicate whether there is a time limit on the full warranty. In a limited warranty, you limit the warranty in some manner, such as to the return of the purchase price, to a replacement, or some limitation in some other way than you're offering a limited warranty. Now, a violation of this Act for a $10 product can be costly, as I said, because a consumer can sue you, cover attorney's fees and damages. So you need to be careful in making either an express or implied warranty or a warranty by mistake when you're writing your sales copy.
This is the end of Side 1. Please turn your cassette over.
Now, sellers making express warranties prohibited from disclaiming or modifying the implied warranties of merchantability. In other words, the law is going to say that you can't disclaim that if you choose to make the express warranty. And also, they won't let you disclaim the fitness for a particular purpose warranty. Now, sellers can still set a time limit on the implied warranty if it corresponds to the time limit on any express warranty. Now, here's where our protections come in as marketers. An express warranty can be limited by a disclaimer as long as the warranty and disclaimer can reasonably be construed to be with each other. Example, making an express warranty in one part of a sales presentation, while disclaiming the warranty in another part. The courts would consider the disclaimer to be unreasonable and therefore void. Now let's look at the magic words of disclaimers. And the reason I call them magic words is because you need to have them stated in a certain way for them to have legal effect. Now again, as we know, a sale is a contract between the buyer and the seller, and the contract is formed when the buyer gives you the money and you give them the product. Now, implied warranties of quality can be disclaimed by words like as is, with all faults, or other wording that makes it clear that there are no implied warranties. So this is something we want on our website under our legal disclaimers. Such disclaimers are effective whether oral or written, but it is always best to reduce them to writing for your own protection. Now, implied warranty of fitness for a particular purpose can be disclaimed without specific use of the word fitness. The disclaimer must be in writing, and you must use wording such as there are no warranties other than expressly stated here. Now that should suffice as a sufficient disclaimer on your site. Again, we talked about this earlier. The disclaimer requirements are that the disclaimer must be conspicuous and noticeable to be valid. How do you do that? We talked about checking the box before proceeding further. Different color print, larger font. Of course, disclaimers that are patently unfair will not be enforced by the courts, and the legal term they use there is unconscionable. The courts look at several factors in order to decide whether or not a disclaimer is unconscionable, and that's the sophistication and education of the parties, the bargaining power of the parties, and whether the contract was offered on a take-it-or-leave-it basis. So that's why it's important earlier when I said you are choosing to do business with us. You can see where all this wording ties in order to protect you. Now, I'm going to talk about some software license warranty disclaimers, and the only reason I'm going to do that is because the software disclaimers provide some good language that we can use for our other products where it would apply. Now, let's see. It's better to have protective language on your website, even when it may not be upheld, than not having it at all. Now, software licenses are complex, and they should be drafted by an attorney, and software companies generally license their software to users. And as you know, everybody here, I'm sure, has bought software. The software license is a contract, and before proceeding further, usually by installing the software, you need to check their little box. Now, licenses set forth the warranty disclaimers and limitations of liability to minimize their exposure. Now, generally, you have 4 clauses in every license: a limited warranty, a customer remedies section, a no other warranties clause, and a no liability for consequential damages clause. Now, that's very important because that limits our liability for business losses. Remember in the example that I gave for the surge protector, where their computer's ruined and they lose their business record. So that's why that disclaimer becomes particularly important. The limited warranty clause usually contains language, at least for software, that the software will function for 90 days and that any express and implied warranties are limited to that time. Now, you also need a declaration on your warranty or disclaimer web page that says some states disallow limitations clauses. Some states do not allow limitations on duration of an implied warranty. So the above limitation may not apply to you. If you've ever read a warranty, you've probably noticed that language. That's important language to have. Some states do not allow you to sell consumer products as is. And in those states, a seller will have implied warranty obligations that can't be avoided. But we need to protect ourselves from everything else as best we can. At this time, those states are Alabama, Connecticut, Kansas, Maine, Maryland, Massachusetts, Minnesota, Mississippi, New Hampshire, Vermont, Washington, West Virginia, and the District of Columbia. Now, Customer Remedies Clause generally states that the entire liability of the company and the purchaser's exclusive remedy shall be a refund of the price paid or replacement of the software. Again, this is something that we could adopt to any of our products. The company then generally will limit replacement of the software warranties to 30 days or the remainder of the original 90-day warranty, whichever is longer. Another statement limits the remedies to the United States. That's very important. You want the remedies limited to the U.S. where we do business. Also, you want to state that no other warranties clause will disclaim all other warranties express or implied, including implied warranties of merchantability and fitness for a particular purpose. Now, the disclaimer goes on to advise that the limited warranty gives you specific rights, and you may have other rights that vary from state to state. It's important to have a no liability for consequential damages clause. Again, this is what we were talking about earlier, where the damages can far exceed the small cost of the product that you're selling. So that the state, you need to state that the software company and its suppliers will not be liable for any damages whatsoever, including, without limitation, damages for loss of business profits, business interruption, loss of business information, or other pecuniary loss. Very important statements to have. Including, without limitation, damages for loss of business profits. You certainly don't want to be paying somebody for their loss of their business or their business profit, their business interruption, or the loss of business information, or any other liability theory that they can come up with. Again, you should have a statement that some states do not allow the exclusion or limitation of liability, so the above limitation may not apply to you. Now, generally, under common law, these rights were only extended to the original parties of a contract and not what they called third-party beneficiaries. In other words, if I contracted with you, I would be in privity of contract. It's just a legal term saying we entered into the agreement, and a third party that was suffered damages or injury from the product, even though they weren't in the original contract at common law, couldn't recover. But that's all changed now. And the current law and the Uniform Commercial Code limits the doctrine of privity, and third parties who are injured by products may be able to recover for breach of the warranty. Now, to make matters worse for us as sellers, the limitations of liability and disclaimers may be ineffective against third parties. And the legal rationale for that is that third parties don't have the knowledge of what disclaimers were originally entered into. Now, again, these legal concepts, how to minimize your liability under the federal and state laws when doing business all online, are an important part of doing business on the internet. Well, let me get into this, and then I want to get into the other topic that you said you wanted to get into earlier, which is licensing and reprint license rights and the damages that you can be liable for are really scary when we get into that. So I'll tell you how not to violate those laws, including setting a price in a license of what your product must be sold at. Those damages, when you do that, are extraordinary, yes. Is there anything that you can do retroactively for products you sold in the past? And the answer is no, but it certainly is not too late to start now. You know, you need to start now. Does the duration of the warranty, if you give a lifetime warranty, does that mean that you have to stay in that business for a lifetime? No. If you have a limited liability company, which you should, such as a corporation, then if the corporation's out of business, then that's the end of that lifetime warranty. That's probably what you see on TV when these companies, you know, advertise these knives with a lifetime warranty. Which of the limited liability companies gives you the most protection? Corporations are the most popular, again, but a limited liability company. It all depends on your situation. That's something you need to sit down with your accountant and find out. Are warranties transferable for the warranties of the products that you sold? Maybe, maybe not, depending on whether he took over the existing company, as he says he sometimes does. Again, it would be on a case-by-case basis. Well, how would he not be liable? Well, if you just bought out the company and just made it into your corporation, a different name, you know. Yeah, the question is you're buying out the asset. And then so if you're selling those assets or you're selling the product under your business, then the business that you bought the products from, if they go defunct, then no, you're not going to be liable for the sales that they made. I think you're foolish if you don't have a limited liability company to do business under, whether it's a corporation or whatever it may be. And for those that may not know what a limited liability company or corporation does, if somebody sues you and you're doing business, let's use a corporation for an example. You're doing business as a corporation. Then what that does is it limits your liability to the corporate assets. They can't come after you personally. However, if you're not incorporated or you don't have a limited liability company, then they can go after your personal assets. So you're rather foolish not to incorporate or set up some type of limited liability company. Yes?
Are suits happening and are they increasing?
Are lawsuits happening and are they increasing? If you go to Google and you do a search for Federal Trade Commission plus fines, you pull up thousands and thousands of hits on it. And yes, whether they're increasing or not, every day somebody sues somebody else for something. And, we live in a litigious society. And that's just the way it is. And you need to take these precautions to protect yourself and your hard-earned money and your hard-earned assets as best you can. Yes, sir. The question is, if you have a website in the UK, would you be able to utilize the disclaimers and warranties on your site? Is that correct? Yes. The answer is yes, because if you're doing business in the US, you need to comply with the laws of the country you're doing business in. So you certainly don't want to be coming to the US if somebody sues you. So you would want all these things on your site. Yes. Yes. The question is if you're selling internationally, do you need to comply with 237 countries law? Yeah. The question is what constitutes where you're doing business, where the corporation is, where the server is, And the answer is the courts would look at both of those. Some courts have ruled that where the server is located, that's your place of business for purposes of suit if you're on the internet. If you have a company elsewhere, then the courts would just look at it and make a decision. Yes. Are there different stipulations for services versus products? No. If you're selling services or products, you need to have these disclaimers and warranties, although you may get into some product-specific law which may not apply to services. And there's a distinction under the UCC that we mentioned earlier, which is the Uniform Commercial Code, which in all 50 states, at least in whole or part, that they rely on. Is there any value to having an alternative dispute resolution agreement on your site? Now, an alternative dispute agreement, most of us have heard the term arbitration or familiar with arbitration. Yes, if that's the route that you want to go, it's certainly cheaper than going through the courts, and that's why alternative dispute resolution was set up. So if you want to put arbitration or some other alternative dispute resolution on your site, then it's going to keep you out of court. At my site, at the very bottom, you will see a link that says disclaimers, warranties, and your legal rights, or something to that effect. Now, is that ideal? As we now know, no, it's not ideal. But I'm comfortable with it, that people notice it, but not comfortable enough not to pay somebody to make that software that I developed. So I'm going to have that up shortly. And that'll be an expensive software too, and that's something everybody should have. Yeah. The question is, do I have some type of an entry-level package? And the answer is yes. On my site, you'll see a website legal package, which has all the custom warranties and disclaimers, that I would draft for you, and I would license that to you, and you would put it up on your site, and I'd check over the site and see if there's any glaring problems that jump out at me. No, it's all state. Yeah. I think it's a $697 or something like that, and that includes my taking the time to review your site and custom make the documents for you. Any other questions? Yes, sir. The question is, if you're conducting sales through a third-party processor like ClickBank, what level of protection do you have by doing business through them? None. None. I mean, that doesn't relieve you of any liability that you may have for what you're selling. Yes, sir.
You said that informational products have less liability than manufactured products?
The question is, do I think that informational products have less liability than manufactured products? No. No. A lot of depending on what the informational product is, I see e-books out there on how to lower your income tax, and if you're selling stuff like that, and you're an accountant maybe, but if you got that from somebody that you don't know on eBay and they're selling that book, you're going to have potential liability. So, it depends on what you're selling. But no, informational products are right up there. Yeah. How about fiction? Question is, how about fiction? We can all make money with fiction and be safe, I think. Yes, ma'am. The question is, when you give a free ebook or a free course, do you still have liability? Yes. Yeah. Yeah, the question is, even fiction has disclaimers. I guess it does. Yes, it does. Any other questions? Yes, sir. The question is, if he puts that there's a guarantee in his informational product ebook, does that mean that the person that he's guarantees their satisfaction and they have a right to a refund, or does that mean that he's guaranteeing everything in the ebook? And the answer is, it depends how it's worded. It certainly should be clear that you're only referring to the refund, but as we know now from our short time here together, that you don't have to say it to have liability. I mean, you know, just from your sales presentation, you can have liability. Yes, sir.
What if you're a consultant and provide services including?
The question is, if you are writing a web copy for somebody and you're getting a percentage, do you have any liability if problems arise? Is that basically the question? The answer is, you don't even need to get a percentage to have liability. Web designers, copywriters, everybody that had anything to do with the sales presentation has liability. It extends that far. So if you're writing copy for somebody and they have a problem, you're going to have a problem too. Yes, sir. When you're talking about a guarantee and a warranty, what is the legal distinction between the two, and are they interchangeable? I think that when you talk about a guarantee, I think we tend to refer more to, if you don't like it, if you're unhappy, satisfaction guarantee or your money back, as opposed to warranting something that this will perform in a certain way. Any other questions? How much time? Yes, sir. Okay. The question is there any other profession other than lawyers that are more efficient at generating income other than lawyers? I think doctors with their lobbyists are right up there. All right, I'm running out of time. They're holding up a sign, and they want me off of here in a few minutes. Let me take one more question, then I'm going to run through this that I need to run through. The question is if you have 5 different websites, can you limit your liability to each website by itself, even though they're all out of the same office? And the answer is yes. If you had a different company for each one, yes, you could do it that way. Yes. The question is, can you tell somebody what to sell a product for? And the answer is no, you cannot. They're free to sell it for whatever they want to sell it for. Listen, I hope you all learned a little something, and I appreciate your time, and it was a pleasure talking with you. Thank you very much.
Again, everyone, I'd like to welcome everyone today to the conference call. My name is Armin Morin, and you are on the Big Seminar Preview Series. And these series of calls that many of you have been experiencing for the last several weeks, We've interviewed many of the different speakers that we're going to be having at the big seminar, all of our faculty members that will be teaching people for 3 full days in San Francisco on the August 22nd, 23rd, and 24th. And these speakers are really the top of the line, some of them the best Internet marketers that there are, not just in the U.S., but in the world. These are the people that are making it happen. And what I did is I invited them all to one place at one time in order to teach you how to succeed online. Each one of them has a specialty, and they're going to teach you for 3 full days what that specialty is, how you can take your business to the next level. That's the thing that many people have a hard time with is I know what the Internet is. I've tried a couple things. Some of them worked, some of them failed. But really, I'm trying to learn exactly how to do it from someone that is doing it successfully. And if that was the question to you, what would be the best thing that you could do? Well, that's to get as close to you can as to these people and to learn as much from the people that are currently doing it right now. And that's what we provide you at the big seminar in San Francisco. If you haven't heard about it, or if this is the first time you're on one of these calls, go to the website. You can read all about the different speakers. You can hear from previous attendees. You can hear from previous people that have been there and what their experience is. You can read it. You can listen to them. You can hear every one of our speakers. You can see videos of the people from our last seminar and get a feeling of how it is and what it's going to do for you. Many people, even the most successful marketers that we had last time, have increased their business by 100, 200%. I was talking with several people today as a result of what they learned at the seminar. Now, that's an incredible testimony from people that are already successful online. Imagine what it can do for you even if you're just starting online, getting the right step. So we're going to talk more about the big seminar later on, but tonight's call, as part of our series, to kind of give you an idea of some of the things that we're going to be talking about at the seminar, we're going to be talking with Bob Silber. And Bob Silber is a tremendous, not only marketer himself, but he's also an attorney. And we're going to find out from Bob some of the legal aspects of running an online business. The fact is that many of you probably are not doing what you need to do. And I was guilty just like you were as well. In fact, what I did, because I didn't know what I was doing as far as protecting myself online, I hired Bob to actually help me with my online legal strategy. And we're going to get some tips and tricks today. We're going to talk about many of the popular issues that are happening right now online as we speak. And we're going to try to get as much information from Bob as we can in the next 60 minutes. So you're in for a real treat. So ladies and gentlemen, I'd like to introduce Bob Silber. Bob, welcome to the call today.
Thank you, Armin. Thanks for inviting me. I appreciate it.
Well, Bob, let's do this. What I've been doing is actually asking people just a little bit about themselves so people understand what their background is. I know not only are you an attorney, but you're also an internet marketer as well. In fact, I know when I first got online, I bought several of your products.
Yeah, I was interested in internet marketing for many years, and many years ago I got involved in it, and I really enjoy it. Producing products and just making money like everybody else does out of info products.
Well, let me ask you this now. You're an attorney. In fact, you not only are you an attorney, but you actually teach too.
Yes, I'm an adjunct professor at Florida Atlantic University, which is one of our larger state universities in the state of Florida. And I teach business law, which now encompasses, because of the Internet, it encompasses all types of intellectual property, including the Internet regulations, FTC regulations, trademarks, copyrights, patents, and any other area of the law that relates to doing business.
So basically anything having to do with e-commerce.
Correct.
Okay. Well, now let me ask you this. I know you and I have had several discussions about many things online, and recently there's been a lot of I guess you'd call it buzz about the law and the internet due to several different factors. I know a couple marketers and a couple companies have really been singled out, let's say, by the FTC as far as what they were doing, and and some of us, for example, I mean, in my opinion, I didn't think that they were really doing anything wrong except maybe some wrong wording on their site. And so, I mean, would you dare to say that the wording on your site, as far as what you have and what you don't have, is going to determine how legal you are as far as doing business online?
Yeah, exactly. The Federal Trade Commission, the FTC, regulates the Internet. And, of course, before the Internet, they regulated any other type of advertising. And they look at the Internet. If you have a business or a commercial website on the Internet, then you need advertising copy, the copy that we all write to sell our products or services. And, they regulate direct mail, television, radio, and all types of media. And, as I said, with the advent of the Internet, of course, they were given a new branch to regulate.
Now, the one aspect that the FTC, I mean, when an FTC, for example, it comes to a site, let's single out a site. Let's just say, my big seminar site.
Right.
Okay. For example, I was pretty careful when I wrote this, knowing what's been happening online, and I know one of the things that I didn't do, which I really wanted to, because I do know a lot of the success stories that our speakers have had. But one of the things that I didn't do, and I refrained from, if you look through that whole website, I didn't mention one single dollar figure as to what people made.
Well,
and
that's probably a good idea, because that's one of the things that the FTC zeroes in on, is any type of income claim that people make. I mean, there's a lot of things they zero in on, but that's certainly one of the things. And if you do make any income claims, you better have it substantiated and proven. And then you're also going to need disclaimers. What they want are the disclaimers on there that these results may not be typical, or that these earnings may not be reflective of what you would make if you make anything, and those type of disclaimers.
I mean, I know many of us, we basically, let's say, get overzealous in our attempt to sell a product to the consumer. And what happens is, we utilize, obviously, the income claims, because many times, even though it's true, it may not, we can't use it. I mean, is that right? I mean, even though, say that, I made X number of dollars online, and I couldn't use that, or I shouldn't use that, let's put it that way, in my marketing efforts?
Well, you can use it if it's substantiated and proven, but what you need with it, you're going to need an earnings disclaimer stating basically that, that doesn't mean that the person buying your product or service is going to earn the same thing, and also a disclaimer that they may not earn anything. That's what the FTC looks for.
Okay, so basically anything that we have to say, we have to have a disclaimer saying that something to the effect of that, even though I made this, you may not necessarily make this as well, because it's based upon my efforts and my marketing strategies that I used.
Exactly. And a good example of the disclaimers is, when we watch TV, let's take, for example, the drugs that we see, the drug ads on TV. At the end of every ad, you'll see a disclaimer. Basically, they're making statements of the side effects that the product may cause. Now, they're not doing this to sell more product, because obviously it has a chilling effect on their ad. They're doing it because they want a disclaimer in there to protect themselves from the FTC. And oftentimes the disclaimer they're using, it sounds worse than what you're trying to cure.
Yeah, exactly.
So they're not using it just to be your friend or to make more sales.
Right. So I mean, would you say that? I mean, let's say from me again, I'm a marketer at heart. Would you say that if obviously we have to have this thing or we're liable? I mean, let's go in the opposite end of it. Let's say a person doesn't have this disclaimer piece. What could happen to them?
Well, a good example of what could happen is the recent case that involved a marketer that we all know, where the government decided they were going to take action against him and come in and seize his assets, his business assets, his personal assets, shut his business down, and basically, they got a court order that really prohibited him from getting money in any way, including borrowing it or against assets he had. And, the power the FTC has is just awesome. I mean, it may even surpass the IRS.
I mean, especially when it comes to our business. I mean, for example, many of us are doing this full time, and you take away, anyone's living. Obviously, that creates a burden.
Well, what they did is they took away all his personal and business assets. So, he basically was left with, he didn't have $1 to buy a quart of milk if you wanted to go buy a quart of milk. They're just devastating when they come after you that way.
Right. So this is the part where we put the fear of God into everybody.
Yeah. And rightly so.
And God being the FTC.
Yeah. Exactly.
Now let's talk about some of the things that a person really should have on their site. I mean, what are the key essential ingredients that a person should have on their site?
Well, if they go to your site, the big seminar site, down at the bottom, you'll have various disclaimers. You'll have disclaimers, warranties, earnings disclaimers, terms of service, and privacy statement. Now, that's getting those disclaimers, if you have the money, that's the easy part. The difficulty comes in is, it's not just enough to have the disclaimer, because the FTC wants them presented in a certain way. So basically, the FTC says that these disclaimers should be interspersed in your website copy. So we all know as copywriters that's really going to have a chilling effect on our sales. So one way around that is the FTC says that if the disclaimer is long enough, in other words, if it just doesn't fit in with the statement that you're making, that you can direct the person to the longer disclaimer. Now, one thing we should all realize up front is the FTC doesn't care in the least about us as marketers. They are only concerned with the consumer and protecting the consumer. So, if we're not following the rules, they're going to come after us.
And that's something we don't want.
Exactly.
Now, let me ask you this. I mean, with those various statements, and I know, most of us it's a bunch of legal jargon that we probably don't necessarily understand. As far as what they mean and why they're even applicable. I mean, can we cover, let's say the different pieces here? For example, on my big seminar site, and if I scroll down all the way down to the bottom here, I have the warranties, disclaimers, and legal rights. I mean, essentially, what does that cover?
Well, the warranties and disclaimers and legal rights, let me go to the big seminar site, basically is going to have just a general disclaimer, a little bit about what you warrant and what you don't warrant for your product that you're selling. And also I include in mine what they call a choice of form statement, where if somebody sues you, they are going to have to sue you where you live, or at least you have put that out there, so you have a better chance at being sued where you live. Let me just state that none of this is foolproof, but it certainly puts you in a better position legally to have all this stuff. Now, I clicked on your disclaimer and legal rights page, and on my computer it just comes up with the first couple paragraphs.
Yeah, I just noticed that myself. What I did was I created a pop-up, and one of the things I didn't do is put a scroll bar on the pop-up. So that's my fault. So in case
that money and you're not.
So in case anyone's wondering, that's my fault. I configured my pop-up wrong, so I need to fix that today. But if you go there later on, it'll be working.
And the other thing that you're going to see there is, we do a lot of the web, the internet is obviously global. So we do business internationally, and there are some choice of, in other words, choice of language a clause in there that you're going to need, because if you're sued by somebody from some other country, you don't want everything on your site interpreted, in the language of another country. I'll give you an example, Dan. When I went to Australia, everybody speaks English, but some of the words there just don't have the same meaning that we have here in the U.S. when we use them. So that's another protection on that particular warranties, disclaimer, and legal right.
Okay, now the terms of service, that basically just tells us, would you say that tells us what we're actually offering?
Yeah, the terms of service basically is just telling the consumer what your website rules are. And, if you read through that, basically it's putting everybody on notice how you do business so that they're not going to come back with a lawsuit, later and say, well, we didn't know that you did business this way.
Now, here's something I think that's probably confusing, and quite honestly, I just noticed this myself, is that a person's privacy policy, for example, I have a pretty long privacy policy here, and that you helped me develop there, and that privacy policy though is something that most people don't have. Most people, if you click on their privacy policy on many individual sites, I know a lot of the bigger corporations usually have this big book that you got to read. But a lot of the small sites saying just something really simple like, we respect your privacy and we're not going to sell, rent, or lease your name.
Right. Well, that may not be enough. So what we're doing with the privacy policy is, protecting ourselves from lawsuits down the road in case somebody, you take somebody's email address and then do something with it, and down the road they're filing a lawsuit saying, well, I wasn't aware that you were going to do that with my email address or my name or my information. So this is what we're protecting against. And one of the things in there you'll notice is a reference to COPA, or the Children's Online Privacy Act. And Mrs. Field's website and Hershey's website a couple months ago were fined $100,000 and $80,000 respectively, because they had privacy policies. They had lengthy privacy policies, but apparently the attorney that drafted them didn't draft them properly, and they were in violation of COPA, and they caused some heavy fines because of that. And basically Mrs. Field's Cookies was taking information from children 13 and under for some kind of birthday club or something, I believe, to where they would give a free birthday gift on their birthday. Really criminals, and they got a $100,000 fine for that. And Hershey's had a more general website, which involved taking information from adults or children. So you need to be careful of these things. You need to know what you're doing when you draft them, and you need to make the statements on your site that's going to protect you from the FTC when they come in.
Now the FTC, for example, they're apparently right now, from what I understand and what I've been seeing, because I go to their website every now and then just to, just kind of see what's happening,
right?
See what they have out there, and certainly they've been targeting some of the what I would refer to as, not legitimate companies out there in the marketplace. But the average person, the average Joe, do they need to be worried that the FTC is going to come? How would the FTC find people?
Well, they find you two ways. Let's say you had a customer that was dissatisfied and made a complaint to them. That's one way. Have you ever had a dissatisfied customer? We've all had customers that no matter what you do, bend over backwards, they're just not happy. So they go and make a complaint to the FTC, and the FTC visits your site. And the other way is they're just out surfing around and looking at sites.
Right. So basically they'd find your site, or a customer complains, and here's something I heard, and again, but I heard that it doesn't take a lot of complaints to get them to start investigating you.
No, it doesn't.
No matter how many customers, no matter, for example, like myself, no matter how many thousands of customers I have, it could just take one or two customers, and they could come investigate me, and if they find some little minuscule thing like Mrs. Fields and Hershey's, and find me $100,000.
Yeah, exactly. So you need to. You need to be following the laws that they want you to follow. It's just like driving a car. We all, need to follow the traffic laws, or you get cited for not following them. And it's the same way doing business on the internet, or doing business in any type of media, really.
What are some basic steps that a person can take? For example, let's say a person was just getting online today. Okay, they're just getting their business. Let's say they don't have an existing business whatsoever. What would you say would be the things that they should do immediately as far as setting up their business and getting started?
Well, the first thing that everybody should do, you should just set aside the money for it, is to register some type of limited liability company, like a corporation.
Okay.
And they need to do business under the name of the corporation. And the reason for this is just basic business, online or offline. And what that does, it protects your personal assets in the event that you're sued by a civilian. It may not protect your personal assets from the government, but from the standpoint of being sued, it's going to limit your liability if you're doing business as a corporation or some other limited liability company. So that's the first thing.
Now, and it's just because I know there's a lot of people that probably don't know as much about maybe creating a corporation. And now, when you say corporation, okay, let's say an LLC. And I'm terming an LLC separate from a corporation. Okay. An LLC, and then you have your various types of corporations. Out of the various types of corporations, as far as what we're doing, and let's just assume that the majority of people on here are selling maybe an information type product. Which would be a better, or which one has more advantages?
The limited liability is what you're after from a legal standpoint. So as to which corporation, whether it's a subchapter S corporation or a C corp or a LLC, limited liability company, I'm going to leave that to your accountant when
right.
you talk to him.
Hey, Bob, I just got an email. In, and some of the people are saying that they can't hear you very well. So if you could talk maybe just a little bit louder.
Yeah, is that...
Oh, much better.
Okay.
Much better.
Better?
Yep.
All right, just let me know if if it's difficult to hear me again.
Okay. I just got an email in, so we're
Okay.
just want to make sure everyone can hear you. So we're going to start all over from the beginning.
All right. We'll extend it another half hour.
So basically, what you'd advise a person to do is really, sit down, figure out what they're looking for and what they're trying to cover themselves, and then really sit down with maybe their lawyer and their accountant.
Yeah, it's just like opening a business in the brick and mortar, as we call it.
Yeah.
Brick and mortar business. There are certain things you need to do, and it's the same doing business on the internet. I mean, just because it's easy to get a domain name and set up a business, in order for you to be protected, you want to consult with your professional accountant or your attorney or whoever that may be. Right.
And they can guide you in as far as the right steps.
Right, exactly.
In order to do that. Now, I mean, let me ask you this, because I know you deal with a lot of people in a lot of different categories, really.
Yeah.
I mean, I know you've dealt with people as far as helping them. For example, I mean, I went through you I had one of my products trademarked and copyrighted.
Right.
And I know you do that, and you've worked with many different people as far as helping them do that type of stuff as far as intellectual property. And the internet, because it is really intangible, let's say we can't really feel or touch anything that we sell for the most part. How important is it for a person to protect their intellectual property?
Well, it's very important because the internet certainly makes it easy for people to steal your intellectual property, and as you know from reading the marketing forums, I don't think a week goes by where somebody doesn't post a problem where somebody came in and stole their intellectual property. So you need to copyright it, and if you get to the point where you're branding yourself or your products or your services, you want to also think about getting a trademark too.
Right.
Now most people don't know. The copyright laws, the trademark laws, they can be very misleading to the layperson. For example, I see posted at the marketing forums all the time that you have an automatic copyright when you write something. Let's say you write an e-book or your website copy. So technically that's correct. You do have an automatic copyright under the recent copyright law changes that we have. But the problem is if anybody steals your stuff, if they infringe on your copyright, if you have not spent the $30 to register it with the Copyright Office, you can't go into federal court and you can't sue them. So a requirement for any lawsuit is that the work be registered. So the advice you see on the marketing forums is don't worry, you're automatically covered, although it's technically correct. It's bad advice in that people should know they need to spend the $30 and register their copyright, or they're not going to be able to do anything legally in the court.
So let me ask you this: we have I have a case example that happened recently. There's I got an email from Stephen Pierce, and Stephen had run across a site that looked when you went to it, it was not only it didn't even only look like my site, but it was all my wording. It was 100% my ad copy. And there was no change except for their product in place of them.
There was no change except where to send the money.
Yeah, that was the biggest change.
Right.
They did change that part. But they did change. The only thing that they did change was the name of the product, and they put it to theirs. And I looked at it, and I sent the guy an email, and it was changed almost instantly. But the thing is that because even though I may have, let's say, trademarked that product and copyrighted, that product itself, or in the process of, because I didn't necessarily copyright my sales letter, the only thing I could really legally do is basically make him stop. Is that right?
Well, in the end, if you wanted to go to court and get damages for them stealing or infringing on your work, it needs to be registered. There are other methods that you can use to, by notifying their ISP, their internet service provider, that they're infringing on your copyright. You can notify their merchant account. That there are various steps that you take to get it removed.
But ultimately, I could just get them stopped, maybe shut down, maybe just cause them a world of grief. But if I actually wanted to collect a dollar figure in damages from them, I couldn't do it because that sales letter was never actually copyrighted, the wording itself.
Correct. Absolutely correct. And also, if you run into somebody that disputes it, that says, no, this is not infringing on their copyright, then the ISP is taken off the hook, in the merchant account, and they probably would reinstate whatever pages that they had removed.
Then the thing is, though, is that I think sometimes, and I know there's, for example, let me give you another example. I had a friend of mine that owns an autoresponder service. And there's another company that owned the autoresponder service as well, too. And they've been going back and forth for, I don't know, a few months, let's say. And saying, because the names, to me, the names don't even sound familiar. And they really don't. Let me give you an example. I don't really want to use the names. But let's say one was... I'm trying to change the names here. Well, okay, let's just say one was Pro and one was Profit.
Right.
Okay. And even though it doesn't, obviously, Profit has Pro in it, it's an entirely different word.
Right.
I mean, and that's my thinking at least. And so they've been going back and forth, trying to do this. Whole thing. One says that he's infringing upon their, wording and stuff like that, and it didn't make sense to me. And obviously, no legal action has been taken. And quite honestly, I don't think it really could. I mean, in a case like that.
Well, if they had a trademark, let's say their series of products or their products that they produce, if they branded themselves with Pro or Profit. If they could show that somehow this was misleading to the consumer in the marketplace, that then there may be some basis for, relief there. But from what you're telling me, they don't.
Well, it's just let me give you an exact example with that's fictitious, but this will make it more realistic for people. Okay, let's say I own the domain, which I do, called adresponder.com.
Right.
Okay. Now I own it, and let's say I put that up there, and I'm successful in doing it, and I'm branding it as obviously adresponder.com.
Right.
Now another guy comes along and says, I've got the domain name, starts an autoresponder company, and he calls advertisingresponder.com.
Uh-huh.
Now, I wouldn't have any claim to him using that name, would I?
You wouldn't unless you had a trademark. Let's say
if I had adresponder, but I was actually saying that my adresponder on my website was actually the domain name might be adresponder, but I might be advertising responder on my website.
Right.
And that may be my legal name that I trademarked.
Right. So
does that sound right?
If you have a trademark, then you're going to be in a better position to, go in and ask for relief, and that it's confusing to the consumer or that they're infringing on your trademark.
So it's like the people that go out and cyber squat.
Right.
For example, like someone going out and registering Oprah.com.
Right.
And then wondering, and then Oprah comes along and says, hey, that's my name. And that's what people are going there looking for is me. and you have this, and I can take that domain name away from you.
Right. The decisions in those type cases, that they go to WIPO, the World Intellectual Property Organization, for domain name disputes. They were appointed to handle those disputes, and those decisions have, gone both ways. If you appeal from their decision, then, if you're in the U.S., you'll be in federal court, and, oftentimes the federal courts have overruled the WIPO decisions and granted relief. So, it's not black and white, but certainly if you, have a trademark, you're in a much better position to get relief.
So basically what you're saying is anything that we feel is important to us, that's going to be important to our business, we should, trademark it as far as the name goes, and then copyright the material.
Correct. And
that would be our best legal action. This way, if someone ever comes out and tries to, let's say, rip us off.
Yeah, which happens all the time.
Which certainly happens, quite a bit on the internet. Sad that it may be, but it does happen, and we can actually. But if we have that in hand, we can actually do something about it.
Exactly. So if you have adresponder.com and you have that trademarked as a series of, software products or whatever, and somebody comes along and puts theadresponder.com, then you'll probably be able to get some relief, because of your trademark.
But let them get to a big company before you sue them, right?
Right.
Don't do it over nothing. I mean, geez, come on. No, that's the thing, though, is that I think America really is a sue-happy society now in many cases. Not everybody.
No question about it.
And even though we're online and we think we're not actually dealing physically with the public, which we are not, but we still have the same responsibilities as a store like a grocery store, and someone walks in and slips and hits their head on the floor.
Yeah, exactly. So, we may be a litigious society. I don't know whether that's good or bad. There are other countries. I guess if you're in Afghanistan, they don't sue you. They just shoot you.
Right.
So, maybe it's not a bad thing to...
No, I mean, I think there's
differences in the courts every now and then.
I mean, obviously there's the places where it's legitimate, yeah. And then there's the, let's put it this way: it's gotten to a point where a hot cup of coffee, gets you $2 million.
Yeah, those things happen.
And so what I'm saying is that for everybody on the calls, for everyone's benefit, is that you don't know what happens to somebody. I mean, let's cover some of the things that a person could even remotely try to nail you on. I mean, here's a couple that I thought of off the top of my head. Let's just assume that you sell someone an ebook, and all of a sudden they download the ebook and their computer crashes.
Right. Listen, you can be sued for anything. Let's say that the software was defective and crashed their computer, or even worse, wiped out their hard drive or something.
Right.
All their business records were there, and they have all kinds of lost business records and lost profits. You need to, like we said in the beginning, do business as a limited liability company, a corporation, so that at least you're protected personally.
Now, here's another subject, and you and I have had this conversation, and this is one of the most shocking things to me, and that is resale rights.
Yes,
resale rights, are something that is. It's just amazing when I first heard you talk about this, what the end person is actually responsible for. And
the resale rights basically, are regulated also by the FTC, and what can happen with your resale rights, depending on how they're presented, they may be violating the antitrust law. And you have serious problems and liability if the FTC comes after you for that.
So the antitrust law doesn't just apply to Bill Gates.
Exactly. It applies to the individual or the mom and pop operation, or the one person website, equally as it does to Bill Gates.
Right. I mean, I think some people, because they think, well, I'm just this little guy and I'm selling this one little book. Obviously, antitrust, that's just reserved for the big companies.
Right, but it's not.
And, could you explain to people really, what that means in layman's terms as far as the antitrust and price fixing and things of that nature?
Well, the price fixing and the antitrust laws make it illegal for you to, basically set a price that in your license, let's say you're licensing an e-book or you're licensing software, the antitrust laws make it illegal for you to tell the licensee, the person getting the license, what they can sell the product for.
Okay. So basically we just can't tell someone what it's selling for, but now there's something else that I know that many people are utilizing right now, and actually it's something I never asked you about as far as opinion goes regarding it, but it seems to makes a lot of sense to me, is to sell people a license to use the product, and if they violate the terms of that license, then you can take away their rights. I mean, is that right?
Well, let me explain it this way.
Okay.
If you issue somebody a license and it tells them that they have to sell the product at a certain price, to me, that's illegal. It's violative of the antitrust law. Now, people have asked me recently about the Colgate doctrine, if that's what you're referring to. And, it's like I get these emails, and it says this is not a chain letter under, and it cites whatever federal statute.
Hey,
well,
Dad.
Have you ever gotten those?
Yeah, I'm the one that sent it to you.
Well, that
I still didn't get that. I still didn't get that $1.
That doesn't mean that it's not a chain letter. Now, there are defenses. The Colgate doctrine is a defense that can be raised, but my opinion, and I'm conservative when I advise my clients,
sure,
is that you just don't get into those things because it's too difficult to apply. The FTC doesn't agree with you on that, and they're going to take you down with it. Now,
but basically,
we've had cases that have gone to the U.S. Supreme Court, okay?
Mm-hmm.
And the U.S. Supreme Court has reversed the FTC. Now, do you know how much it is to get to the U.S. Supreme Court?
I would probably say about $250,000 or so.
It certainly could be that much. And on top of that, after you spend your $100,000 to $250,000 to get there, and that's not litigating it in the Supreme Court or arguing it.
Right.
After you get to there, the Supreme Court. Do you know how many cases they take out of the thousands and thousands of cases every year?
I don't know.
They take about 75, 85 cases every year. And out of those cases, it has to be a major societal issue because obviously they just don't have the time to, hear all these cases. So if one of those cases got to the Supreme Court, chances are that they wouldn't hear it, and the lower court's decision is going to stand. And, like I said, I'm kind of conservative. So my clients, I don't want them, facing $100,000 or $50,000 just to go to the U.S. District Court, or $100,000 to fight the FTC on the issue, where they may lose. And even if you win, what do you win? I mean, you've lost $100,000,
sure.
$150,000, $200,000 in fees and costs.
There was a marketer that did fight it. I believe it was Joe Polish.
Yeah, I don't know about Joe's case.
And I believe it was Joe Polish. I'm not sure. I could be wrong, but did fight and just spent a huge amount of money for basically nothing. And obviously, I mean, ultimately what we're saying is that this is just some general guidelines, and that for a person would actually need to sit down with an attorney, to get actual legal.
There are 1,000 cases that are litigated on that subject, where people have, it's just bankrupted them or it's cost them a fortune, and that's because it's not clear cut.
Sure.
The FTC looks to protect the consumer. They don't look to apply these, defenses, so to speak. So, it's a defense you can use in court if they go after you. But listen, I don't want to be in court. I don't want my clients in court if they don't have to be.
Now, let me, I know we're getting towards the top of the hour here. As far as a lot of this, there's obviously a huge amount of information regarding the legal aspects of your business, and quite honestly, for the different types of businesses, there's different legal requirements, especially online. I mean, now, what's your opinion? I mean, here's my take, and tell me if you agree with me or not. But I think as the internet becomes a more and more dominant place in the marketplace, that there's probably going to be specific laws set up for online business. That'd just be my general observation. I mean, what do you think on that?
Well, the laws that they apply now, certainly carry over from the brick and mortar businesses, and we're all susceptible to following them, and we need to follow them. And, so those laws come into play automatically. And then, yes, as we go along each year, Congress passes some type of new law to, regulate some aspect of the Internet or to protect, consumers or business people on the Internet. So, yeah, we not only have laws in place that apply to the Internet that were developed pre-Internet, but we also have laws each year that are passed that specifically for the Internet. And
because if you think about it, I mean, many people. I mean, let's face it. I mean, the majority of people that are making up the laws right now are not the youngest of age. and quite honestly, it's a fact that the people that are more elderly have a harder time utilizing computers and technology. They just don't want to adapt.
Right.
And I'm saying what I'm saying is that probably again, general observation, but a lot of the politicians that are out there and controlling our fate in our business are probably not the most technologically savvy people there are in the marketplace, and probably don't understand even what our business is, or even remotely want to understand what our business is. But as more and more people, are accustomed to the electronic universe, the Internet, things may go in our favor, things may go against us. Who knows? It's only time will tell.
Exactly.
But Bob, you're, we've only had a little bit of time to talk about a few different subjects today on the call. But maybe if you could go over a little bit for people what it is that you're going to be talking about at the big seminar.
Yeah, what I want to talk about at the big seminar, which I think would help everybody, is, Armin, as you know, I had some top marketers literally pay me thousands and thousands of dollars to review their website, so just to make sure that they were FTC compliant. And what I'm going to do at the big seminar is basically tell the attendees exactly what I told my high-paying client what they needed to do and how to protect, themselves from the FTC scrutiny and the changes that they needed to make to their site. So I think that'll be very helpful to anybody that has access to that information. A lot of people have paid me a lot of money to get that information, and at the big seminar, I'm going to cover that and let everybody know just what I told the big guns, so to speak, what they needed to do.
And, and one of the parts that I know many people enjoyed at the last seminar is where we had the question and answer period.
Yeah.
Where they could actually ask you a few questions and things, and maybe
I'm always happy to answer questions, and
maybe I'll grab a microphone and run around and play Phil Donahue.
Oh, that would be good. We haven't tried that format yet, and maybe we could ask the attendees if they would like that. And if
we'll
they
see.
would, then that would certainly be a new concept.
We'll see what happens there at the seminar, and either way, I know you're going to give some tremendous amount of information there. Again, thank you for taking the last hour out with us of your busy schedule. I know you're busy with different clients and different projects and things of that nature. So again, thank you for being here.
Well, my pleasure, and I'm looking forward to seeing everybody in San Francisco. Listen, I love your events, Armin. I mean, I just do. You know how to throw a party. That's what I say.
This one's going to be bigger and better than ever.
Yeah, it is. I actually can't wait. I can't wait.
The one thing that I was thinking is that I really need to think next time before I actually name my seminar, because if I don't want people going around and calling it BS2. So we're going to keep the long version, big seminar, for the time being. But again, folks, we just spent an hour with Bob, and Bob shared some great information, and hopefully you took some notes. And again, it all boils down to is seeking proper legal counsel. Whether it be with Bob or an attorney, or some other attorney, it doesn't matter. There's plenty of people out there that are well qualified to help you. But I would definitely, here's my little bit of advice for you, is to find someone that actually specializes on the internet, that has some knowledge about the internet. Chances are your personal lawyer has no clue about internet. So find someone that specializes in that, and that they'll probably help you the best. But we're gonna we only had a little time to talk with Bob today, and he's going to have a lot of time at the seminar to go over many different aspects that he couldn't possibly cover on this call with me in the way. So what we're going to do is we're going to have him at the seminar. He's going to be talking all about the legal aspects of your business there, and where you can get a lot of great information as well. And again, folks, it's we only have a few short weeks away from the seminar, and what we're doing is this. We're having a tremendous amount of people coming on board to the seminar. We're getting more and more sign-ups every day. We're well over 200-plus people that are going to be there. And, I can give you all kinds of reasons why you should come. Okay? There's so many different reasons why you should be there. A, obviously to build your business. That's one reason. B, which is probably an even more important business, not only to learn about the Internet and marketing online and how to do it properly, but also the networking aspect of it. There's many people that you'll meet there that are very successful online. There's many people in our audience that are very successful online, and obviously, the speakers that are going to be there are very successful in their online businesses. And the different parts of the seminar are really threefold. I was actually doing some drawings today for some posters that we need, and it came down to three things, and this is what our theme of the seminar is going to be. And A is education, B is leadership, and C is friendship. That's what it really comes down to in three words. The summary of the whole big seminar is you're going to learn about marketing and how to do it properly online from the people that are currently doing it. And then that brings up another small subject I want to cover, because this is, every once in a while I'll go off on these rants. And here's one of the rants. One of the rants is that is that there's two types of marketers out there in the marketplace. One is an active marketer. What I mean by an active marketer is one that's currently selling products and services online. The other is what I call an inactive marketer, people that at one time were marketing but are no longer marketing anymore for whatever reason. Doesn't matter. The point is that every one of our speakers there are active marketers, meaning they're currently derive the majority of their income not from coaching people, I should say, or just teaching people about the Internet. They're currently selling their own products and services online. And many of these speakers have markets that are totally unrelated to Internet marketing. In fact, the majority of many of their incomes come from a different type of industry altogether. And they're going to teach you what's currently working on the Internet. The last thing you need to hear is from someone that actually has been in business or is not marketing online at all telling you how to run an Internet business. That bugs me, because this person has no idea of the day-to-day operations as far as what's currently working online. Let me give you a short example. I've been doing some studies that I'm going to reveal at the seminar regarding email. And I shouldn't say regarding email, but it's about building a list and opt-in boxes and what works and what doesn't. I went through 8 different tests in the last 6 days as far as building my list and what the percentages are. One word will actually make a difference of about 10%, or basically outpull the other one by as much as 1,500%. And I'm going to talk about that at the seminar. What I'm telling you is this: the reason why I'm saying all this stuff is that myself and all the other people there are currently and actively marketing online, and they're going to teach you how to do the same thing. There's only a few short weeks left for the seminar, so what we're doing is making sure that you all, if you're interested in coming, go to the website, click on the button, and order your seat to the seminar today. We're running out of rooms at the hotel. I can tell you that 100%. You can call them up and you can find out, because that's just a fact. We have some special deals, though, at the hotel that after you order the seminar seat itself, you'll actually get an email with a discount code that will give you just about almost a 50% discount off the hotel room. Normally it's $159 a night at the hotel. We actually get it down to $84. We get a discount code that we can give you for American Airlines. It will save you 10% off American Airlines. We also have another discount code for car rentals if you need that. Chances are you won't. One of the things that we're doing about the seminar this time as opposed to last time is actually I'm covering all of the meal costs except for breakfast the whole weekend. What I'm doing is I'm covering your lunch and dinner on Friday, your lunch and dinner on Saturday, your lunch on Sunday as well, too. And it's all included in the price of the seminar. Not only that, we have actually several different gifts for you, different tools that I felt that are necessary, things that are out of my marketing Rolodex that I put on the CD that we're going to be giving you there at the seminar as well. And here's the other part to this. I've offered this several different times before, and I'm going to offer this again to everybody. Everybody that orders and comes to the seminar is also going to receive, I'm going to put a time limit on this because we're making CDs right now as we speak, is the actual calls. You've heard some great information on this call. We've already done, I don't know how many different calls on about the seminar so far. I think we've done about, maybe 8 or 9, 10, something like that so far. I know there's only a few speakers left, but we've done each one of these calls, and what I did is I recorded each and every one of those. Many of you have asked, how do I get my hands on these? Come to the seminar. That's how you get your hands on these. And the reason is that I'm actually going to take these calls. I've already formatted them into an MP3 format. I'm going to give them to you as an instant product. It means that you have the MP3s. You also have the actual the website already. It's a turnkey website, and you'll be able to actually sell these calls. There's a lot of fantastic information that we're given here over the course of this time that majority of people couldn't get on these calls because most of the time we were sold out on the calls and they couldn't access the call whatsoever. So what I'm doing is this. I'm making another offer. It's actually, today is July 31st. Okay, anyone that signs up for the seminar by Sunday, which I believe is August 3rd, is actually going to receive the resale rights, the full 100% resale rights to these preview calls. That's actually 13 different speakers, the top internet marketers in the world on this, and I can tell you this, there's not too many people that will be able to get all 13 of these guys on individual calls giving you the ability to market them. I don't think that anyone's been able to do that yet, and some people have come close. But we have really the best of the best. Some people you'll never ever hear on a CD, or you certainly never hear in an audio course. And these guys are on these calls, and you can have access to market these particular calls to your list on the internet with a turnkey website. It's a tremendous value. If you sign up for the seminar by August 3rd, you're going to receive that at the seminar. We're going to give it to you. You'll be able to go home and market that product immediately. And we're going to talk about the pricing about that at the seminar. That's a heck of a product for you to market. So again, I urge you to really take a look at the big seminar. Come down and meet us there. And we're having another call on Saturday. And on Saturday, we're going to be talking with many. I couldn't tell you who we were talking with exactly on Saturday, off the top of my head. If not, if we don't have someone else on Saturday, I'm going to be talking with you on Saturday. So we'll figure that out as we go. You'll receive an email notification about that. Now, Bob, are you still with us?
Yeah.
Okay, Bob. One of the things that I've been doing on these calls is actually giving away the tape set from the last seminar, which
Wow.
you were also one of the speakers. And now I really kind of screwed up. I screwed up last Saturday, and here's what happened: is last Saturday I interviewed Joe Vitale, who you know, and when I did that, I forgot to actually give away a tape set on that call. So some people emailed me about that, and so what my response was, I'll have to give away 2 on the next call. So what I need from you is 2 numbers between 1 and 364.
All right, let's reward the first one, number 1.
Okay, number 1, that was easy. I didn't have to look too hard for that one.
All right.
The number 1 is Ava, A-V-A, I'm going to butcher this last name, Barsvi. That's B-A-R-Z-V-I. That's Ava, A-V-A, Barsvi, B-A-R-S-V-I. Ava, what I want you to do is simply email us at bigseminar.com, support at bigseminar.com, and we will get your tape set. It's a 14 tape set. It's that tape set with Bob's on there as well as many other people. You'll actually get that tape set in the mail rushed out to you tomorrow. So that's the first one.
And let's reward the last one who just barely made it.
The last one who barely made it, okay. You made it easy. It's easier for me to search this way. And the last one who just registered for the call was Ellie Ditzel. Again, that's Ellie Ditzel, Ellie, and then I hope I'm saying this right, Ditzel, D-I-T-Z-E-L. It's Ellie Ditzel. So that's Ava Barsvi and Ellie Ditzel. Again, both of you, if you just simply email us at support@bigseminar.com and let us know where to send that tape set to, we will get that tape set out to you immediately. Also, there's one more thing I want to mention on this call, is that one of the things, some of you may be avid golfers out there. Well, we're doing something a little different at the big seminar. The day before the seminar, the Thursday, the 21st, we're actually having a big seminar golf scramble, which means many of the speakers who can't play golf, and I can tell you this, I stink at golf, and many of the speakers, and also we have several people who have already registered for this, are going to come out, and we're actually going to play golf in this golf scramble. Now, exactly what a scramble is, I have no idea, but it sounds really fun. What we're going to do is we're going to play golf all Thursday morning. We'll provide the transportation to and from the hotel, so you don't have to worry about that. But it's going to be a tremendous time. It's going to be great. We're going to have a lot of fun. I know Stephen Pierce, he doesn't even want to attempt to play golf, but what he's going to do is he's going to drive the golf cart for someone. So, I know many of the people. I know John Reese is going to show up for the golfing. I believe he's going to show up for the golfing, and there's many other people that are going to join us there as well. Many of the speakers, and we're just going to have a great time. But that's the golf scramble. And after you sign up for your seat at the seminar, you're going to get more information on the golf scramble, so you can actually register for that. It's going to be a tremendous fun event. In fact, what we're doing is I'm actually videotaping the different parts of the golf scramble and playing it back on Saturday night after dinner. On Saturday night, though, this is something I didn't mention, Saturday night, we're having a tremendous dinner banquet. This is, Bob, you mean the last dinner banquet that we had? Tell everyone a little bit about it. I mean,
the last one, it was just like a party. I mean, everybody loved it. Everybody had fun, great food and drinks, and I can't imagine you topping that. But knowing you, I'm sure you will.
Yeah, I mean, just to kind of give everyone an idea, what I mean by dinner banquet, I didn't throw burgers and hot dogs on the grill.
No, you had the best food, prime rib.
Yeah, we had prime rib, we had salmon, we had there was 3 or 4 different types of food there. It was a great, huge dinner buffet that we just put out there, and it was great. It was tremendous. And then after that, we actually had an affiliate award ceremony, which we're going to have this time as well too. And I'm going to be really curious to see who's going to win the affiliate award ceremony, because I got some really special prizes this time. And bonus gifts. So we're gonna do that. We've got many people coming. I know many of the different people coming that they're actually bringing bonus gifts that we're going to be giving away. We're going to be giving away many different things throughout the event, and there's still some surprises that I'm working on that I will only reveal at the seminar. And again, I say this on every speaker call: none of the speakers know what I'm talking about. So it's going to be a surprise for everybody that's going to be there. So we're gonna have just a great time. Again, I urge everyone just to come on out, join us. It's going to be fun. The biggest thing is that not only is it going to be fun, not only is it you're going to learn from people, you're going to get to meet the people that you've heard on the phone. You're going to, I'd love to meet everybody that's on this call right now, and we're going to really teach you how to build your business. And it really, really makes a big difference. I've said this before, and I'll say it again. My business before, I had a successful business before I started going to seminars. I'm not going to tell you it wasn't, because it was. But after I started going to seminars and I started networking with people, my business just really skyrocketed. In the past year, my business has literally quadrupled in size in 1 year. And it's just amazing what can happen with the right contacts by circling with the right people. And, many of the people that was at that first seminar that I went to came up through the ranks with me. Was it coincidence that we were all friends and came up at the same time as far as our business is growing exponentially? No, I don't think it was. It was that we were all striving for the same thing. We shared the common problems. We shared the common, concerns. We shared the successes with each other, and it was just amazing. And, it's going to happen to you too. People are too busy looking at the person ahead of them to think that person up in front of them, no matter what you're doing, is the one going to be helping you. No, that's not the way it works. The people that are going to help you move forward are the people next to you. The people that are next to you that are, and when I say this, I mean this literally and metaphorically, is that the people that are next to you are the ones that are going to rise, let's say, through the ranks with you. Their businesses are probably around the same way that your business is right now. It may be just starting. It may be a little bit more advanced. In fact, some of the people that are going to be there are way advanced. Some of the people that are going to be in the audience should be up on the stage, because these guys have extremely successful businesses, and you're going to see what I mean when we get there. I don't want to reveal their name on the phone, but you're going to see exactly what I mean. But yet they're coming here because they want to expand their business, and they understand the value of education. Education is the key to business. The more you know about business and your particular market and your marketing strategies, the better and bigger and faster your business is going to grow. If that makes sense to you, I urge you to go to the website, reserve your seat today. And with that, we're going to be having a call on Saturday. I'll be sending an email to everybody in the next day or so, and you'll be able to jump on that call and hear some more great information. So again, Bob, thank you for joining us tonight.
Thank you.
And again, everybody, I hope to see you at the seminar. And again, that offer that I offered you was simply you get all the rights to all these calls that we've recorded at the seminar, and if you order by Sunday, August 3rd. I've offered this 3 times now, and some tremendous people are taking advantage of that. So, again, we'll talk to everyone on Saturday, and everyone have a great night. Bye-bye.
Bye. Thank you.